development in a case of another parent charged with murder, Casey Anthony, and it's today's trial track. In a wild move, Casey Anthony's defense filed a motion for the judge to remove himself from the case, and in-session correspondent Beth Karras has looked at the documents. Beth, why do Casey's attorneys want the judge out of here?
Well, the judge has had a few communications with a blogger who actually won an award for being a great blogger in the Orlando area, and while he writes about other criminal cases, he spends quite a bit of time writing about Casey Anthony's case. In fact, he started attending some of the hearings in the case, and the judge apparently recognized him, and at the end of a hearing on October 16th, he asked the deputy sheriff to go and get Mr. Dave Neckel from the public gallery and bring him up to the bench. The hearing was over. The judge spoke to him. Mr. Neckel was contacted by a defense investigator last week, and according to Neckel, who goes by the name Marinade Dave, the judge told him that he reads his blog post, that he thinks is the best blog out there, and that it's very fair. The judge also, some months later, in February of this year, initiated another communication with Mr. Neckel when he learned, apparently by reading the blog, because Neckel didn't tell the judge, he posted that he was going into the hospital because he had a heart condition. The judge took it upon himself to call him. Neckel told the investigator he didn't know how the judge got his number. It's an unlisted number, Dave Neckel's, but the judge was able to contact him and wish him well.
Hold on. Come on, Beth. The phone number is right on his blog. Report the right information, please.
He can't do that. Most importantly, the judge is saying that this is a good, fair blog. I really like it. It's the best one out there. It may be a reflection of the judge's own position on the case. And Mr. Neckel definitely, many times, says things that are anti the defense, pro-prosecution, like Casey Anthony must die.
Wow. And so he's saying that. Is the defense in their documents using anything else the judge has said to say this is why he needs to be removed from this case?
Yes. You know, they're also saying that the post by Mr. Neckel after the October 16, 2009 encounter increased about the judge, and they got very favorable toward the judge, and that maybe the judge was courting this blogger to get favorable media attention and press about himself. The things that Mr. Neckel said about Judge Strickland, positive comments, really increased after that. And now here's an excerpt from an October 27th, 2009 post. That is just 11 days after the judge first spoke to Mr. Neckel. Mr. Neckel writes, after my experience in the courtroom at Casey's last hearing, I read several comments elsewhere that questioned Circuit Court Judge Stan Strickland's wisdom because he acknowledged reading my blog. You see, Mr. Neckel had posted on October 19th that they had spoken. Then he goes on to say, upon watching him in the courtroom, I found his candor to be quite refreshing, and I welcomed his open-mindedness. I saw live how sharp and focused he remains at all times. He is very well-mannered, well-informed, highly intelligent, and because of his personality, humble to boot.
Wow. Okay. Well, Beth, thank you. And you know what? Let's get some opinions from our experts. In-session legal contributor Sunny Hostin is in New York. Law enforcement contributor Mike Brooks is right here in the studio. And from Miami, former Florida Circuit Court Judge David Young. Welcome, everyone. And Mike, I want to start with you. So the defense is talking about here some deliberate courting, and this Judge Strickland is interested in publicity. Is that what you see here? Do you see Judge Strickland as a publicity-driven judge here who maybe should remove himself?
Well, you know, I think he's done a good job so far. He seems to be fair. He seemed to be impartial. You know, is this going to change that a little bit just because he had some contact with the blogger? But, you know, he's also a judge who is elected. So what is he doing? Is he doing this to play the kid to his constituency, if you will? First of all, you know, as a former law enforcement officer, I have an issue with judges, district attorneys, and sheriffs being elected. You know, these are all people.
All right.
You know, so I don't.
That's a whole side thing.
There you go.
Yeah.
No, but you know, is he playing to the crowd? Is he playing to TV? It's hard to say right now.
Yeah.
You know, a lot of people say yes, he's doing this for the publicity, but there's nothing really to prove, you know, factually that he is.
You know, Sunny Hostin, is he crossing the line here? Is this just too much? I mean, it's one thing to say you like a blog. It's another thing to approach a guy in court and say, you're great, and then call him in the hospital, and especially when he's writing things like this that could be seen as pro-prosecution.
Well, absolutely. I mean, as a judge, you are an elected, in this case, official, and you have to be impartial, and that is one of the job descriptions. Now, anything that I think connotes sort of this appearance of impropriety is something that should be, it's a hands off. And the fact that he has not only, pulled this person sort of into his world, up to the bench, and complimented him, but reaching out affirmatively to call and find out, how someone is, I think is very problematic, especially given the state of law in Florida, which makes it clear that it's not whether or not the judge thinks he or she is impartial, it's whether or not the moving party, the defense in this case, believes he can be impartial. And I think the answer to that is no. And so I think that the bottom line is he's probably going to have to recuse himself.
Wow.
Here.
Okay. Well, Judge David Young, what do you think about that? Do you think this is the kind of situation where Judge Stan Strickland may end up having to remove himself?
I think there's a possibility. I think what the judge did was no act of malice. I think he was trying to be a good guy. But unfortunately, in a death case, death is different. And if it was just one or two instances, I would probably say, I wouldn't worry about it, but it seems to be a collection of things. But your viewers need to understand that what the standard is in Florida is you have to assume that everything is in that affidavit is true. Then the next step the judge has to do is, does it state is it legally sufficient? Now, in order for it to be legally sufficient, it has to be on an affidavit, signed appropriately by the affiant, and the individual's got to heard this within 10 days. If it's past the 10 days, then it's not legally sufficient. In this case, you have none of these allegations were done within the last 10 days. These were done over a year ago. So I really don't think it would pass legal muster. I think if the judge denies the motion, I think that the court will uphold the denial. And also, what would happen in this case, it would not be a bearing on the guilt or innocence of the defendant, but instead they would take an immediate appeal. So an appellate court would weigh in whether or not the judge is right to recuse him or herself.
All right. Thank you, Judge David Young, Sonny Hostin, Mike Brooks, and, of course, Beth Karras. Thank you so much. We appreciate it.
My personal opinion, which I wrote already on one of the videos, is to keep your personal life personal and don't blog what happens. Simple. Very simple.